and welcome. Still got a few folks coming in, but I think it's about time for us to get started. Welcome to the University of Richmond, to those of you who have come from afar for our Law Alumni Weekend and reunions. For others who have come a very long distance, we're thrilled to have you on this side of the Atlantic. And for law students and faculty, thanks for staying around on a beautiful Friday afternoon when it's hard to resist going outside. This is the kickoff event for our Law Alumni Reunion Weekend, and we're especially privileged this year to have with us the newest member of our law faculty, Governor Tim Kaine. It's been a great privilege for me this fall semester to be able to introduce Tim Kaine as a member of our law faculty. Many of you may know that Governor Kaine taught here at the law school back before he began his active career in politics. He taught here for 6 years, principally in the area of legal ethics, while he was at the same time a very well-regarded and able practitioner of civil rights law here in the community of Richmond. Governor Kaine, of course, was the 70th governor of Virginia. Before that, he served the Commonwealth as lieutenant governor and the city of Richmond as Richmond's mayor. He currently holds the chairmanship of the Democratic National Committee, which means he spends a lot of time on airplanes, traveling all around the country, obviously, in that pursuit. He's got his undergraduate degree at the University of Missouri, and then he and I actually crossed paths, however briefly, in our academic careers when he was a student at Harvard Law School. It's our privilege to welcome him back to our faculty and to have him with us this afternoon. Governor Kaine.
Hey, thank you all very much. Thank you, and I'm looking forward to just a good discussion with all of you today. I'm teaching a course to third-year students at the university, at the law school here, The Future of Equality in American Constitutional Law, and I'm going to boil the course down to 1 hour, and you will not have to turn in a 30-page paper. So, I mean, it's amazing what we're going to be able to do here over the course of the next hour, but I definitely want to encourage you to jump into the discussion. I want to thank your dean, John Douglas, who has been a longtime friend since I first moved to Richmond, for his kind words and for the pleasure of coming back here to work together. I love being at UR. I was here for 6 years, as your dean mentioned, and really am happy to be back. I also have a particular fondness for this room. I did a major civil rights case in 1998 that led to the largest civil rights jury verdict in American history, and I did the moot court of it right here 2 weekends before we put the case on trial here in Richmond. So every time I stand here, I just get a warm and fuzzy feeling, but it's good to be here with you. And what I want to do is basically just kind of, as I say, do a quick run-through of a part of American law that is large and complicated and not really subject to a quick run-through, but that is of enduring fascination to me. I think it's kind of the North Star of American law, politics, and history. That is an area where there is also a lot of current legal ferment. And I'm going to talk about the history till I get there, but this is what I call the sort of the equality doctrine in American law. And it's largely the doctrine about the 14th Amendment, the Equal Protection Clause, and there's a wonderful book that I would recommend to you, very readable, by Garrett Epps, a Richmonder, who now is a professor at the University of Maryland at Baltimore, called Democracy Reborn, that's about the drafting of the 14th Amendment in the aftermath of the Civil War. So I would recommend that to you. The story really starts before the 14th Amendment, so I want to spend a few minutes talking about sort of equality in American law, and then there have been two periods in American law where the equality principle, though it was fundamental, have kind of disappeared. And so I'll kind of march through the history a little bit. You have a set of handouts, and the thing that I would most love you to do, that we're not going to really go through the handouts during the talk, except for I want to spend some time looking directly at the text of the 14th Amendment, which is on the second or third page of your handout, if you might get that ready. So we'll go through the history a bit, but then I want to get into three current controversies that deal with the 14th Amendment. One case is dealing with affirmative action. largely that stemmed from two decisions that the Supreme Court made in 2003 and how they are applied going forward. Two, a set of two cases currently dealing with marriage and the marriage rights of same-sex couples, one a Massachusetts case, one a California case, both federal district court cases that are definitely going to be appealed, hotly appealed, and will likely reach the Supreme Court at some point. And third, some current controversies and cases dealing with immigration. All of them have their roots and origins in, or will be decided by courts wrestling with the language of the 14th Amendment. But let's start at the beginning before we get into the drafting of the 14th Amendment and just, kind of begin with what I call this notion that we have a North Star in American political history and law, and that is the concept of equality. I view it as a North Star to our American story. It's a star that sometimes is obscured by a cloud and sometimes can be seen, and we see a legal doctrine that has shifted over time, but it is an exciting story as you look at the path of the development. So, we begin with the Declaration of Independence. The first self-evident truth is what? All men are created equal. Jefferson, writing that doctrine as the drafter of the Declaration of Independence, it is largely a bill of particulars against King George. But before we get to the Bill of Particulars, we make that wonderful assertion, one of the most famous pieces of prose in the English language. We hold these truths to be self-evident, that all men are created equal and that they are endowed with certain inalienable rights, and among those rights are life, liberty, and the pursuit of happiness. I said inalienable. He actually wrote unalienable. It used a archaic phraseology, but the first of the self-evident truths, all men are created equal. Jefferson wrote that. In the Bill of Particulars against King George, there was also just a very harsh indictment of the Crown for fomenting the slave trade, kind of blaming the challenge of American slavery on the English. Those who read Jefferson's draft thought, well, now that may be going a little bit too far, so they took that out of the Declaration of Independence. But we begin really the kind of story of our nation with that very stirring declaration, which is read, every 4th of July, and that opening phrase is the one we remember, that all men are created equal. 1776. 1787, the Constitution was written, ratified with bills of rights that were added between 1787 and 1791. Where is equality in the Constitution as drafted and ratified? Anybody know? It's disappeared. The first of the self-evident truths, that all are created equal, within 11 years has disappeared. The Constitution is drafted, and there's nothing in it about equality. In fact, inequality is in the Constitution in 3 sections. I haven't put those in the readings, but I bet you can think of at least a couple of them. In that Constitution as drafted in 1787, anybody remember the inequality references? 3/5 clause. So there's a definition of how you count population of states to apportion some funding, but especially to apportion electoral college votes and membership in the House of Representatives. The 3/5 clause was meant to apply to slaves, but the drafters of the Constitution felt skittish about using the word slave, so they didn't use it. They listed who was counted, and then they said 3/5 of all other persons. But by the time you got to that last phrase in the sentence, the all other persons only meant to slaves. They didn't want to use the word slavery. So that's the first reference of inequality in the Constitution. Second, anybody remember one? There was a reference to the slave trade in the Constitution. Again, they didn't use the word slave, but they talked about importation of human beings and said that Congress could not act to forbid that until 1808. But acknowledging that was taking place. And then there's a third reference that's an inequality reference in the Constitution dealing with the duty of states to return fugitives who are under service or indentured servants who escape into states to return them to their owners in other states. So it's an interesting question, and I'm neither a historian nor a legal scholar, but I'm passionately interested in this, and this is the area of law that I practiced, that we begin our national story with 2 foundational documents, one of which says equality is first, and one of which omits equality and actually enshrines inequality. And that's the start, really, of our story. As we move through the antebellum period, and I think that beginning demonstrates an ambivalence that we'll see throughout American life about, do we really believe in equality? The ambivalence could also be explained, hey, we may have perfect ideals, but we're not perfect people. None of us are. So that's part of the ambivalence. We're never completely able fully to understand what a notion like equality means. The framers of the Constitution used that other wonderful kind of bizarre phrase, in order to form a more perfect union. There's no such thing as more perfect. But they used it because I think they had an understanding that, you know, the only way for something to be more perfect is if the wisdom of tomorrow is more elevated and ennobled than the best wisdom of today. So I think they had a notion of evolution in that phrase, more perfect union. So some of the ambivalence about equality is we figure things out later that are injustices that we accept today as, you know, as just the way things are. There's also an ambivalence over equality for another reason, which is we tolerate all kinds of inequalities in life that will never be the subject of any kind of legal remedy. You can't have equal outcomes to everything. So the definition of what equality is and how we're going to try to make it work has been this thread that's been going through the cases. Okay, we get into the antebellum period, and you've got a constitution that does not guarantee equality, in fact enshrines inequality, and what you see is a whole series of cases between the 1770s and between right on the verge of the Civil War, where there are, you know, inequality is the outcome of cases. A wonderful case in the 1820s, Jackson versus McIntosh, which is a case dealing with land titles granted after the Revolutionary War, and land titles that were granted by Indians before the Revolutionary War. And Justice Marshall wrote a famous case that said, basically, you know, when it gets down to it, the courts of the conqueror cannot deny the facts of the conquest. And so the granted titles of the titles granted from the Indian chiefs didn't count, and the titles granted by the American government after the Revolutionary War were the ones that were the most powerful. Cases dealing with women, with Indians, with freed blacks during this period amply demonstrated that there was no such thing really as an equality notion. I found equality mentioned for the first time, and I'm sure that if I searched more I might find an earlier reference. Equality was mentioned for the first time in a major way in a case that many of you are familiar with. I think, John Pagan, I think you taught this case. It was a case that was decided in the 1840s, the Amistad case. So many of you have seen the movie The Amistad, or you have read of that story. Slaves who have been kidnapped from Africa come through Cuba at a time after Spain had declared slavery illegal. They were on a slave ship. They hijacked it. The ship ran aground in Long Island. There was then a trial about what was to happen with these individuals. And there's a very stirring Supreme Court case at the end of the trial when it goes up to the Supreme Court, where the Supreme Court grants the individuals their freedom and says that they're entitled to come before the court on equal terms with anybody and plead the justice of their case, and they are allowed to do that for one reason and one reason only, and that is that they were Africans. They would not have had the right to do that had they been Richmonders shipped to a slave port in Louisiana, hijacked the ship and landed in New England. Had they been Christian-speaking American citizens, Christian-worshiping, English-speaking American citizens, they would have not had the right to petition for equal treatment, but because the court ruled they were African and had been kidnapped, they could ask for equal treatment in the courts of the United States. So during the antebellum period, there were numerous cases affirming the inequality principle that had been enshrined in the Constitution. Of course, other things were going on in the antebellum period. Congress was completely roiled up about slavery. Virtually everything in Congress was getting run aground over issues of slavery. The Wilmot Proviso, the Missouri Compromise, the Northwest Ordinance, the Kansas-Nebraska Act, the gag rule, all these issues were happening in Congress and kind of warping the national dialogue as the original deal became an untenable one. And from a legal standpoint, the original deal probably most cratered in the case of Dred Scott, the Dred Scott case, which I know that many of you know. But just to be very quick about it, Dred Scott, a Virginian, Southampton County, born in Southampton, moved eventually and became a slave to an army surgeon, along with other members of his family. But during his time of service with the army surgeon, moved into the Northwest Territories and into places where Congress had said slavery cannot extend to the territories. And so he appeared in the courts of St. Louis after first attempting to buy his freedom for $5,000 and having the owner turn him down, filed a lawsuit in Missouri and said, because I moved into the territories where slavery was not allowed, I'm now a free man. Case was decided in the middle of the 1850s, and along with a couple of other things was a major precipitating cause of the Civil War. In the Dred Scott case, there were two holdings. The first dealt not with whether he had become free because he moved into the territories. It dealt with, are you a citizen of the United States? An argument that hadn't really been raised below, but the Supreme Court considered it, and the Supreme Court, in one of the most infamous decisions, ruled that an African American could not be a citizen of the United States. Not only could a slave not be a citizen, but even a free black could not be a citizen of the United States. Could be a resident and wasn't a citizen of anywhere else, but this opinion, a very sharply divided opinion that led, I believe in the only time in the history of the Supreme Court, one of the Supreme Court justices in the dissent resigned because of the opinion. There was a ruling that African Americans could not be citizens. The second aspect of the case, well, if you're not a citizen, you don't even have jurisdiction to bring the lawsuit, but we'll go ahead and decide it anyway. The court went on to reach it and said, and you're not free because even though you were in the territories, Congress didn't have the right 30 or 40 years ago to declare that slavery couldn't exist in the territories. That striking down of the Missouri Compromise then led, with a whole series of other things, to the Civil War. Through the Civil War, we're going to jump over that period. Everyone here is, I'm sure, an expert in it, but you know, in the aftermath of the Civil War, there are 620,000 soldiers who have been killed, many more who have been injured, many more civilians who have been killed or injured, complete devastation of the southern economy and significant dislocation and devastation of the northern economy, and 4 million slaves who live in the United States have eventually been freed through the workings of the Emancipation Proclamation in 1863. In the aftermath of the Civil War, we are confronted with a massive constitutional challenge. And the Constitution has to be amended, but to the minds of many, almost really has to be rewritten. There's a whole series of questions raised in this book about, when we talk about the original intent of the framers of the Constitution, can you really even talk about the original intent of the framers when the 13th, 14th, and 15th Amendment so dramatically changed the Constitution? The 13th Amendment was the amendment that outlawed slavery. There shall be no slavery in the United States. The 15th Amendment was the amendment that said no one can be disenfranchised on the grounds of race. Now, you could be disenfranchised for other reasons, as folks were for a long time, and that's why we needed the Voting Rights Act in 1965. But the 14th Amendment was kind of the heart of, in many ways, a redraft of the Constitution. As Garrett Epps calls it, democracy reborn. Some of the Supreme Court justices writing in the immediate aftermath of this drafting of the 14th Amendment called the 14th Amendment a new Magna Carta for the nation. And if you'll just take a look real quick, I've got a, unfortunately, pretty small print version of the 14th Amendment, especially for, a 52-year-old like me and maybe some of you, but let me just have you open up to it, because the 14th Amendment is a very long one, and it does a couple of things that are really important. In fact, I think there are about 7 sections. There's 5 sections of the 14th Amendment, but I think it does about 7 things that are noteworthy. The first section begins, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. For the first time in the Constitution, there's a definition of U.S. citizen. There had not been a definition before, and that had led to the Dred Scott case, the fact that we're dealing with a Constitution that doesn't define who a U.S. citizen is. That's the first thing the 14th Amendment does. Second thing that it does, the next clause, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. The Privileges and Immunities Clause, which has been kind of a vague one. It comes into play in a way I'm going to talk about in just a second, but that language is very plain. Privileges and immunities was a phrase that was already in the original Constitution, I believe in the Fifth Amendment, or even in some of the earlier articles. So that was a phrase that was understood at the time, and yet there was concern about states treating each other's citizens the same, so no state shall pass any law which shall abridge the privileges and immunities of a citizen of another state. An important word in that phrase, citizen. The third thing it does, nor shall any state deprive any person, not citizen, any person of life, liberty, or property without due process of law. So privileges and immunities applies to citizens, but deprivation of life, liberty, or property without due process of law applies to persons, which is broader than citizens. It applies to non-citizens. And then the fourth section is that the Equal Protection Clause, nor to deny to any person within the jurisdiction the equal protection of the laws. That also applies to to persons, not citizens. So those are in that first section, there are four pretty distinct provisions: a definition of citizenship, a privileges and immunities protection for citizens, a due process protection for persons, an equal protection process for persons. The next section, section 2, is a lengthy section that is a section that deals with unscrambling the 3/5 clause. So we've said that other persons are worth 3/5 of a human being in the original Constitution, and we have to now unscramble it. But what is the political challenge with unscrambling the 3/5 clause in 1865? I mean, it would seem easy. Why don't we just say, well, everybody's worth one person? That would be the easy way to draft it. But that posed a huge political problem for the Congress of 1865. And what was the political problem? Please. Right. What an odd irony, right? What an odd irony. The southern states got between maybe 20 or 30 seats in Congress because of counting their slaves as 3/5 each. And that was often referred to as the slaveocracy or slave power, and it put the southern states in a really strong position in electoral college politics that led to Jefferson's win over Adams in the presidential election of 1800, and in any action before Congress. And so if suddenly we fought a huge war, and the Union has prevailed, and the outcome is we give the South even more representation in Congress, at that point the Republican majorities in both houses were very, very concerned about doing that. And so they had to figure out a way to end slavery and end unequal treatment, but at the same time not dramatically shift the balance of political power even more to the South. And so what you'll see in Section 2, it's fairly a long and complex section, is this. And it's a section that had a very negative consequence that was understood, and they wish they had avoided it, but they couldn't, is you'll see that they define now, okay, you get representation based upon your population, except for Indians not taxed. They were treated separately until the 1920s, with the exception that if you do not let groups of your male citizens vote, then your representation in Congress is decreased by that proportion. Southern states were disenfranchising African Americans wholesale, but also some whites through uses of poll taxes, literacy tests, etc. And so everybody's going to be equal, but you don't get equal representation. If you disenfranchise groups of males, then your numbers in Congress go down. And that was what in fact happened, because males were being disenfranchised largely because they were black. But what was the bad consequence of the way it was drafted? You can understand it just from looking at the wording. Now, women, right? The bad consequence of it was an equal protection section, and we're trying to protect everybody's privileges and immunities, but it's putting in the Constitution something that had never been in the Constitution before, which was a legal distinction between men and women. Elizabeth Cady Stanton and Susan B. Anthony, when this was being drafted, and Frederick Douglass, who was a women's suffrage advocate, said, hold on a second, if you put this in the Constitution, you're going to delay the ability of women to get the vote, Elizabeth Cady Stanton said, for 100 years. And the suffrage movement was in full force from 1848 on, and suffragists were abolitionists who wanted to end slavery. The suffrage and abolition movements were almost one movement, but with a sword, the Section 2 of the 14th Amendment split those movements in two, provided citizenship, provided equal rights to African Americans, but phrased the voting rights in a way that delayed women's suffrage, not by 100 years, it was actually by about 60 years until 1919. So that's the fifth chunk of this statute, of Article 14. The sixth chunk would be sections 3 and 4, and these are chunks that aren't really used much anymore. They were trying to define the rights of those who had served in the Confederacy, and could they receive political rights. They were essentially disenfranchised from office holding absent special dispensation of Congress. And then section 5 is sort of the seventh substantive chunk of this, and that deals with Congress having the power to enforce the 14th Amendment by law. This is a huge, lengthy amendment that does at least 7 separate, substantive things, including for the first time ever a definition of citizenship in the United States. So it accomplishes much, but it was understood, but kind of they viewed it as a regrettable necessity that it was pushing women's suffrage down the road. It also did at least one other thing that was very, very significant, which is for the first time after the drafting of the 14th Amendment, we began to have a debate about whether the first amendments to the Constitution applied against states. So Articles 1 through 8, essentially Congress shall not, limits on federal governmental power, abridge freedom of speech, pass laws that, or undertake, unreasonable searches and seizures. All of the original amendments in the Bill of Rights were checks against federal power, but not against state power. But because of the language, deny citizens of life, liberty, or property without due process of law. What is liberty? What is a deprivation of property? Abridge privileges and immunities. The court, over the course of the next few decades, not on necessarily equality cases, but other cases, well, what does those language mean? And with Justice Black and others, as many of you remember from your constitutional law case, they eventually used this part of the 14th Amendment to incorporate in to the protections against state legislation most of the original Bill of Rights. So this is this new 14th Amendment, democracy reborn, a new Magna Carta, a dramatic expansion and redefinition of the role of the federal and state governments, all in this one particular amendment. Very controversial. It was passed under some controversial circumstances because the states that were voting to ratify had provisional governments that had been, set up in the aftermath of the Civil War, and the legitimacy of even the enactment of the 14th Amendment was subject of litigation for some time to come. After the 14th Amendment was passed, the equality doctrine almost disappears again. So it first disappears from the Declaration of Independence to the Constitution, but now we've put it in the Constitution for the first time. Equal protection of the laws, for the first time it's in the Constitution, but in the years immediately after the drafting of the 14th Amendment, it disappears for a second time. One of the first cases to deal with the 14th Amendment and what it meant was the slaughterhouse cases, which some of you might remember. It was decided in the early 1870s. And the slaughterhouse cases don't deal with race, don't deal with slaves, don't deal with African Americans, but deal with the power of state legislation to affect somebody's livelihood, whether you can open a butchering operation in a place other than the Louisiana statute said you could. Louisiana had given a monopoly to one group of butchers and said nobody else can do it. 14th Amendment said, hey, this is abridging our privileges and immunities to earn a livelihood. And in that case, slaughterhouse, the Supreme Court looks carefully at the 14th Amendment and says it was to help slaves, but only help slaves in federal rights. The privileges and immunities of citizenship were the privileges and immunities of federal citizenship. And the court did a very careful distinction about the 14th Amendment is only really meant to protect you in the exercise of federal rights. And the right to earn a livelihood isn't a federal right. Or so the court said. The court talked about what would federal rights be, and it was incredibly narrow. The one example that they used, because the court was almost defensive about the case, the slaughterhouse case, and said, well, some may say that we've defined this too narrowly by only saying the amendment protects federal rights, but there are definitely federal rights that are protected. An example would be the right to use a port on a navigable waterway. Well, not every, citizen is just thinking about what's the nearest port that I can use, but that was a federal right that was protected in the slaughterhouse cases. But even the right to earn a livelihood, which is pretty basic, was not protected, and that ends up playing a very significant role in a whole series of other cases. A second case that dramatically shrunk these amendments were the civil rights cases, which were also decided in the 1870s. Congress had passed a statute guaranteeing equality in public accommodations, stagecoaches, trains, hotels. The Supreme Court considered it. Congress passed it saying the 14th Amendment says equal protection of the law, and it says that we can enforce it through enactment of legislation, so we want to protect primarily against statutes that are discriminating against African Americans. They should be able to have access to these public accommodations. The Supreme Court struck it down. They struck it down and they said, no, wait a minute, the 14th says no state shall. Didn't say anything about what private folks can do. So Congress has no power to regulate private behavior under the enforcement section of Section 14. It's only state enactments that are problematic. And so the equality doctrine, which was a huge advance in terms of the 14th Amendment, within 15 years after passage, had basically been shrunk down to virtually nothing. And you're all familiar with the Plessy versus Ferguson case in 1896, a case dealing with streetcar transportation in Louisiana. Louisiana had passed an explicitly racially discriminatory statute. Folks have to ride in different cars based on race. Came up to the court. The argument was this clearly violates the 14th Amendment. This isn't equal protection of laws. And the court's ruling was, well, look, social equality isn't the same as political equality. And separation is not the same as a badge of inferiority. And so there can be separation of races in virtually any aspect of life. And that's not a badge of inferiority. It's not behavior that the 14th Amendment was meant to prohibit. And so by Plessy, 30 years after the passage of the 14th Amendment, this equal protection guarantee was pretty much a dead letter. Well, some of you have read the book called Simple Justice by Richard Kluger, which is a wonderful book about the lawyers at Howard University and the NAACP who mounted a sustained campaign over the course of about 25 years to deal with and ultimately undo Plessy versus Ferguson in education. And I'm not going to go through that history too much, but basically patiently chipping away at it with respect to graduate schools, law school admission, dental school admission, basically using the Plessy versus Ferguson framework. Okay, separation isn't inequality, but if we can show that the two options, the option for African American, whether it's be on a streetcar, a trade, or an education, is definitely unequal. Fewer funds, fewer opportunities, then we can establish an equal protection violation, even under the standard of Plessy. Those cases were advanced, and eventually we get to Brown versus Board of Education in 1954. Brown, an unusual case, like Dred Scott and like the Slaughterhouse case, argued 3 times. Well, Dred Scott and Slaughterhouse were both argued twice. Because they had a hard time making up their mind. I mean, one of the neat things, I guess, about being a Supreme Court justice, you can have the case argued once, and if you go back in the chambers and you say, boy, we're having a hard time deciding. You know what, let's have them argue it again. Who's going to tell you can't do that? I mean, who's going to tell you no if you're a Supreme Court justice? So Dred Scott argued twice, Slaughterhouse argued twice, Brown versus Board ultimately argued 3 times, twice on the liability question. Does the separation of kids in schools violate the 14th Amendment? Then it was argued a 3rd time to try to determine what the remedy is. But the Brown case, which you all know, was kind of the final, cut, okay, de jure discrimination or even differentiation, even if it were equal. And in at least one of the Brown cases that came up, the case out of Topeka, the Linda Brown case, there was arguable equality between the white and black schools, but they were separate. The Supreme Court said, can't do it, separation, this is exactly what the 14th Amendment meant to prohibit, and so now we get to the modern equal protection doctrine. De jure discrimination, de jure separation is wrong. This equality principle that started with the Declaration in 1776, it's taken all the way to 1954, took nearly 100 years to put it in the Constitution, then it took, darn near 90 years to make it meaningful, but now finally there is an equal protection doctrine that is meaningful, and we're in the modern era. In the modern era, though, then we have to wrestle with the meaning of equal protection of the laws. And in fact, the way I look at this is we kind of have to wrestle with the question of how much equality do we really want? How much equality legally does the doctrine suggest that we should go after? And that's kind of what the court has wrestled with in the modern era. And I'll talk about a couple of the strands of this, and then we'll get into the 3 current controversies that I talked about. We tolerate inequality all the time, right? So all men are created equal, and everybody's entitled to equal protection of the laws. But between those two things, there's a lot of inequality that happens. You know, fate, luck, chance, individual initiative. Some are born to wealthier parents. Some are born to less wealthy parents. Some, you know, get a break and some don't. Some work harder, some don't. We tolerate inequalities of all kinds, and we should. There are all kinds of inequalities that are part of life, and that shouldn't be the subject of, you know, a lawsuit saying, no, we have to even everybody out. This isn't a Procrustean bed where everybody has to, you know, have exactly the same outcomes. No, life is much more rich and complex and variable than that, and we know it changes over time. You can be up today and you'll be down tomorrow, and vice versa. So there's all kinds of inequalities that we tolerate. We also are faced as human beings with a tough challenge. Those of us who are writing laws, a wonderful friend, Delegate Joe Johnson is here, who's a member of the Virginia General Assembly, and the task that he and others who are in public life have always had is, if you put words down and you write a law, you're going to make a classification. You know, virtually every law makes a classification between, you know, a group that can do this and a group that can't. And whether it's zoning laws and where uses can be placed, or laws about individual behavior, most laws involve classifications of some kind. And we don't want to have an equal protection doctrine that would, again, be overly harsh, that would eliminate the ability to make the classifications that we need to make in life. And so beginning with a case, the doctrine of standard of review, equal protection standard of review, how do we look at legislative classification, started to develop in kind of a haphazard way in the early 1900s by a famous case, the Caroline Products case, which many of you might remember, kind of a non-controversial case on the issue. But by that case in the 1930s, they were starting to articulate the standard of review. And so basically we end up with, this is kind of the sieve that we put laws through so that most are okay, but we limit the number of ones that we really have to dig into to determine whether the classification violates the Equal Protection Clause. So the default mode, if you're challenging a law for violating the Equal Protection Clause, is, as you know, the rational basis test. A court is going to defer to the judgment of Congress, a state legislature, city council, county board, so long as the classification under review bears a rational basis to a legitimate governmental interest. So you have the classification, you search for any state of facts that would suggest there's a legitimate governmental interest at stake, and then you look to see whether there's a rational connection between the classification and the governmental interest. And that is the standard of review that would uphold, that would give deference to the overwhelming majority of classifications that legislative bodies make. There are a certain two categories of cases that the Supreme Court says, the rational basis standard is not enough. There are kinds of cases where we have to be more searching. And in the Caroline Products case in the 1930s, a famous footnote 4 basically said, there are two kinds of cases where we have to go farther. The first is, if a classification touches upon a fundamental right to practice religion, or in the footnote it lists other fundamental rights, right to vote. If a classification divides people up in connection with a fundamental right, we need to give it a more searching review. Second, if a classification classifies among groups of people to the detriment of discrete and insular minorities, minorities who might not have the political power to get their way in the legislative process is the basis, or oppresses those who have been historically oppressed. We got to do a more searching review as well. And thus was the birth of what was called the strict scrutiny doctrine. So any case that touches upon a fundamental right, a classification that touches on a fundamental right, or that touches upon a historically discriminated against group, gets a strict scrutiny review. And the strict scrutiny review is, okay, we've got the classification. Does the classification address a compelling governmental interest? So not just a legitimate objective, but a compelling governmental interest. And does it address it in the most narrowly tailored way? And if it does, then it can be upheld, but most often the strict scrutiny review takes a look at classifications and says either that's not a compelling interest, or more often, you could do it more narrowly than that. It's not narrowly tailored enough. Now, if the standard of review wasn't even complicated enough with strict scrutiny or rational basis, then in the 1970s there began to be a third standard of review somewhere in between that I can't even describe, except to say it's somewhere in between. It's an intermediate standard of review. So it's between rational basis and strict scrutiny, and the intermediate review has been used in cases dealing with distinctions based on gender, of which the law is filled with them. They don't get the strict scrutiny review because it would, and the court probably wrestled with the notion, well, if you distinguish based on gender, is it a discrete and insular minority you're discriminating against when women are a majority of the population? And so the court wrestled with the notion and concluded that distinctions based on gender should be reviewed in this intermediate category, and the other category that's used is distinctions based on legitimacy. So children who were born to legitimate marriages or illegitimate marriages, that fits into an intermediate scrutiny as well. Most everything else is rational basis, except if you're dealing in areas of race or fundamental rights, you deal with strict scrutiny. That's one of the ways we deal with this how much equality question. Because if we had to look at everything that classified people differently, the federal court system would do nothing but equal protection cases. Because all we do is classify, or much of what we do in passing laws is classify. But the standard of review narrows the field down to a more manageable field in terms of looking at these doctrines. That's one way we wrestle with the how much equality question. Another way we wrestle with the how much equality question is this. Remember, the 14th Amendment was held in the civil rights cases to only apply to governmental action, only to governmental discrimination. How about private discrimination? Well, after the Brown versus Board case had declared definitively that you couldn't do de jure discrimination, private discrimination started to be addressed in a series of enactments: the Voting Rights Act, the Fair Housing Act, Title VII, the Americans with Disabilities Act, the Equal Pay Act, forbidding private discrimination. But since the Supreme Court had ruled that the enforcement section of the 14th Amendment could not be the basis for those laws, all of those laws were based on the Commerce Clause of the Constitution, the ability for Congress to take action to deal with subjects that touch upon interstate commerce. And so when these cases, these civil rights statutes were first wrestled with in the courts in the 1960s, they were justified based primarily on Commerce Clause and other rules and not on that section of the 14th Amendment. The civil rights cases of the 1870s have never been overruled in saying that the 14th Amendment doesn't just apply to state action, it also applies to private action. So that's another how much equality issue we've had to deal with in the modern era. Do we prohibit private discrimination as well? And the answer is in many instances we do. And then finally, on the how much equality question, before I keep telling you I'm going to get into the modern controversies, and I'm going to, you have to deal with one other issue on equal protection, and that is this. Over time, there's been a philosophical debate. Was the Equal Protection Clause, and indeed the entire 14th Amendment, was it about elevating a group and protecting groups, or is it about protecting individuals? Now, the history of it was to protect a group. It was to protect African Americans who had been enslaved, or as free blacks who weren't even considered citizens. So there's a lot of early equal protection jurisprudence that talks about the clause as if it's about the relation of groups to one another. But the more modern trend that now is pretty solidified doesn't look at the history of the 14th Amendment, just looks at the words. No citizen shall have their privileges and immunities abridged, and no person shall be treated in a way that's not, equal or have their rights taken away without due process. So the modern doctrine on equal protection sort of sets the history aside. It's not really about groups, it's about the rights of individuals. That becomes a huge and important issue when we get into cases dealing with affirmative action. Affirmative action would be kinds of cases that you could say, is it okay because of the historic discrimination against a group to advantage a group at the expense of an individual that's not in the group? That would be one way to look at affirmative action cases. There are other ways. After Brown, the equal protection doctrine has flourished. It's used in cases dealing with distinctions based on sex. One of the most common or famous that we would know about, the U.S. versus Virginia case dealing with single-sex admission of VMI. It's dealt with cases dealing with immigration. Distinctions based on immigration, which are looked at on the rational basis side, Probably the most controversial one, still controversial today, Plyler versus Doe, 1982, states if states have compulsory public education, they have to offer that not just to citizens, but to persons. Persons are entitled to equal protection of the law, including persons that aren't citizens. So children who live in the United States who are not U.S. citizens, and that is a huge chunk of kids, especially in some states in this country, are entitled to public education equal to citizens because the language person was used in the 14th Amendment. Race cases, an awful lot of them, you don't see them so often now, but you certainly saw them. Loving versus Virginia, the anti-miscegenation statutes and others were dealt with in the post-Brown era. Cases based on wealth. Harper versus Virginia, poll tax case. Touches on a fundamental right. The distinction is one that's drawn based on your wealth, your ability to pay a poll tax. Supreme Court struck poll taxes down, but wealth classification cases, which are reviewed on a rational basis, if they don't touch on a fundamental interest like voting, you got a lot of those in equal protection doctrine. And then an equal protection doctrine that is definitely a modern one that might not have really been foreseen at all by the drafters of the 14th Amendment, use of equal protection in the political process. So one of the, I remember Tom Clark, the Justice of the Supreme Court, who sat on Brown versus Board at the end of his career, said that wasn't the biggest case he sat on. He thought the biggest case that he sat on as a justice was Baker versus Carr, which is the case one of the series of cases that establishes for principles of legislative reapportionment the one-man, one-vote principle. That if you're going to have a set of legislative districts in a state like Virginia, you can't put 100,000 people in one district and 5,000 in another, because then if you're living in that 100,000 district, you don't get the same proportional representation in the legislative body as the one with 5,000. So that has led to a whole series of laws around redistricting that try to equalize apportionment, whether it's city council, state legislature, Congress. And then there's a whole series of other decisions, all the way up to Bush versus Gore, using equal protection in the political process, either to protect your right to vote, your right to be a candidate, your right to have ballot access if you're an independent, and even sometimes your right to express yourselves in a political context. So the equal protection doctrine now, is going all these different directions. Three current controversies: affirmative action, marriage, and immigration. On the affirmative action side, affirmative action cases tend to kind of come in two categories. There might be more, but the two biggest ones are educational admissions and governmental contracting. Not really going to talk about the governmental contracting side. There's a lot of ferment in those cases, and one of the biggest ones was a case that dealt with the City of Richmond procurement policy, J.A. Croson versus City of Richmond. But I want to talk about the admission to universities and colleges and law schools. One of the most, I'm sure everybody's read the Bakke case. Justice Powell, the Virginian who was such a wonderful justice, one of the most fractured opinions, ever issued by Supreme Court. Justice Powell's opinion was the opinion that people kind of relied on, but it didn't get 5 votes. I think it only got 4 votes. No opinion in that case got more than 4 votes. It was very fractured, but Bakke basically set up the framework about affirmative action in admissions, which is still a very controversial today. Bakke was a case, admission to the University of California Medical School. And whatever the number of seats were at the medical school, they saved 16 aside for minority students who had been underrepresented in medical schools in California. And Justice Powell said, well, you just can't do that. You can't just guarantee that minorities will have access to all of the seats plus the 16, but then say that, white students can only have access to the 100 seats, but not the 16. If you make race just the complete factor, he said, look, it's a race-based classification. It's a state university. You got to look at it with strict scrutiny. And so in that instance, Bakke struck down the reserving of the 16 seats for minority students, but said, but you know what, if you do this right, you can do it. And that was the thing, frankly, that fractured the opinion, because not everybody agreed with, well, what was the right way to do it. But Justice Powell said in Bakke that, look, it is a compelling state interest. It has to be compelling because it's a race classification. We're looking at it with strict scrutiny. It is a compelling state interest to have in our educational institutions diverse representation. Diversity broadly described, not just racial, but broadly described. It's compelling, and so if a university does that, it's okay. That's not what the University of California at Davis had done. Their program was struck down, but it was 25 years from Justice Powell's opinion in Bakke saying you can do it if it's about diversity, till the next set of cases landed in the U.S. Supreme Court. There have been many cases coming up. They turned them away. They took 2 cases from the University of Michigan, which are in your materials, Grutter and Gratz. And I always got to remember which is which. Grutter is a case dealing with the University of Michigan Law School, and Gratz is a case dealing with the University of Michigan undergrad. And both cases led to some fairly fractured opinions, and Justice O'Connor was key, and she was in the majority in one and in the minority in another. But to talk about those cases, undergraduates at University of Michigan, undergraduates had a point system. Everybody applying to that premier university was given points up to 150 points, and then they would let you in, depending on where you ranked. And you could get 20 points for being a member of a historically underrepresented minority at the University of Michigan. The court wrestled with that and said, you know what, that it's kind of syntactically and rhetorically different than the University of Cal Davis setting aside the 16 seats, but in other ways it isn't really. That if you just get that extra points purely because you're a minority, and no matter how good a student you are, that you're not in that minority and you can't ever get those 20 points, the Supreme Court said you can't do it like that and struck down the undergrad admission process at the University of Michigan. Justice O'Connor was in the majority striking down the undergrad admission process. In the law school admission process, however, the law school was doing it differently. They didn't get as many applicants. The law school got 3,500 applicants a year to take 350 students. University of Michigan was probably getting 20,000 applicants to take, 4,000 admittees. And so the law school, with fewer applicants, had a little more time to give individualized consideration to the applicants. And what the University of Michigan Law School did was said, okay, well, we're going to give individualized consideration, and if you are a member of a historically underrepresented minority, that's going to be a plus factor for you. But there are other plus factors too. Overcoming, physical, challenges or other demonstrated evidence that might not show up in your GPA or your SAT score. And the Supreme Court, in a narrow majority, said that's okay. Still, it's strict scrutiny. If you're using race at all, it's got to be a compelling governmental interest, and diversity is, Justice Bakke said it was, and it has to be narrowly tailored. In this instance, if we're looking at everybody individually, it's narrowly tailored. So in the University of Michigan grad law school case, the court said diversity is a compelling interest for our courts, for our bench, for the way we practice in a diverse society. Of course, it's a compelling interest, and so if you give individualized consideration, it's okay. But the thing that's interesting about the law school case is this. In the last paragraph of her opinion, Justice O'Connor said, now, of course, it's been 25 years since Bakke, and society's been getting better and been getting more diverse. And so we really believe that these programs won't be needed in 25 years. So that was in 2003, and she basically said, and it's language that gets debated, is it dicta, is it the holding, how solid is it? And even the dissenting and concurring opinions were arguing about that language. Is that a holding in the case that come 2028, a case will come back to the Supreme Court, and whatever the stats show about the applicant pool and who gets let in, that language is going to come back up. Can we continue to have affirmative action policies that are race conscious, that try to extend and expand the diversity of our student body? And I don't think people know. I don't think people know what's going to happen when we get there 25 years down the road. Is it going to be automatically, hey, we said in the Grutter case that no more affirmative action programs? So that's the open issue in these cases dealing with admission. There's a second issue, or second set of issues that I gave you in the material. If some of you haven't read it, some of you might have seen, but please do. Jim Webb, Senator Webb, wrote an article in the Wall Street Journal about a month, maybe 2 months ago, called "The Myth of White Privilege." It's an article about affirmative action. I talked to Jim, and he said, "I love my article. I didn't like the title they put on it. The editors put the title on." He goes, but I really strongly believe the article. The article basically makes a couple of points. That the history of discrimination against African Americans fully justifies affirmative action and other programs to make sure African Americans are treated equally. He says he completely gets it, and legally and every other reason that's fine. He doesn't address the issue about how long that should be the case, but he says from a legal standpoint, I get it. But he raises two other issues. He says, first, let's be honest, affirmative action programs have disadvantaged some whites, not all, but it disadvantaged some whites. We have to just acknowledge that. The white community isn't monolithic. Some obviously are going to do fine, and so, is it a myth of white privilege when 99 out of 100 U.S. senators are white? I mean, it's not necessarily to say it's a myth when you can show in so many instances whites are way overrepresented, even in proportion to the population. But he would make the point that, it's not white elites who have been damaged by affirmative action goals. It's, often middle class or working class whites who have, and he raises that issue. And he raises it in a way that really needs to inspire some debate. But the second thing he says, which has been quite controversial, is, whatever we think about affirmative action for African Americans, there really isn't a need to apply affirmative action principles to other more recently arrived immigrant communities. And in particular, he doesn't say this, but I think he's talking about extending affirmative action programs to Asian American, Pacific Islanders, and Latinos. There wasn't the same horrific, there's been discrimination even against Irish, right? But there wasn't the same horrific slavery and 3/5 of a person all wrapped up in American law. There's only been one group of people, and arguably two, Indians might fit in as well, but only one group of people that were, enshrined as less than a full human being in the Constitution, and it was African Americans. And so he says, what we really ought to do is be looking for ways to get past affirmative action, get to a better place, a more harmonious place, but particularly for groups other than African Americans, affirmative action remedies really shouldn't be used anymore. One more thing on affirmative action, dealing with these cases, there's a lot of discussion going on about, okay, race-based classifications in affirmative action. Race-based, you're going to have strict scrutiny. Can you try to do the same thing in a laudable way, but not use race-based classification? So Texas and some other states do this. Admission to state universities. If you're in the top 10% of your class, you get guaranteed admission. Now, some kids are in the top 10% of classes that are, all black high schools in the center of the city of Richmond. And some kids are in the top 10% of their high school classes, on Tangier Island with a very different kind of a population. And some are in the top 10% of their high school classes in mega high schools in Fairfax County. But if we let in to our state colleges, you get guaranteed admission in if you're in the top 10% of your class. That has a way of promoting some diversity in who gets in without using a race-based classification. That statute, you get in if you're in the top 10% of your class. If somebody challenged that on equal protection grounds, it would be a strict scrutiny it would be a rational basis analysis. It would probably pass. A college could say, you know what, we're going to give you credit in admission based on your income, family income, socioeconomic status. We think it's a good idea to include people from different socioeconomic backgrounds. And if they did that, that would be a rational basis analysis, not a strict scrutiny analysis. And that might lead to some significant diversity. A university could say, we're going to give you 50 extra points in the 100 to 150 if you're the first in your generation to go to college. Parents' educational status still corresponds pretty closely with race and some other measures. You could give somebody 50 points for being the first in their generation to go to college. That would be a rational basis analysis, not a strict scrutiny analysis. So colleges, I know, are wrestling with this question. Can they meet the diversity goal and do it in a way that really includes full diversity, including racial diversity, but do it by means other than racial classifications? Second, let me talk to you just for a second about the marriage cases, which clearly they've been banging around for the last 15 or 16 years in state courts, but there are now two federal district court decisions, one in Massachusetts and one in California, that are clearly going to work their way up to the Supreme Court. I can't imagine that there are going to be circuit court cases that the Supreme Court is not going to take. At some point, I guess, sometimes the Supreme Court, as you know, will wait until there's a conflict in circuits to take a case, and sometimes they're looking to avoid taking a case as long as they can, and they may do that for a while. But these are cases, this issue is going to come to the Supreme Court. The two cases are different. Gill versus Office of Personnel Management is in your materials. It's a case dealing with the federal statute, the Defense of Marriage Act, which for the first time in federal law defined marriage. Defined marriage for purposes of all federal benefits that depend on marital status. And then also had a separate section that said that states didn't have to recognize marriages that were different than the way they define marriage in their own state. That's basically what the federal DOMA law does. The distinction, the district court analysis in the Massachusetts case, both of these cases the district courts have struck down the laws, one a federal law, one a state law. The rationale in the Massachusetts case was this. First, what's the standard of review? There's a distinction between same-sex and opposite-sex couples. What's the standard of review? Both courts say, you know what, we think it ought to be strict scrutiny, but they're aware that strict scrutiny isn't applied very much, and so they say this flunks even under a rational basis test. So they use rational basis, although they kind of suggest maybe it ought to be strict scrutiny, but they use rational basis. In the DOMA case, the judge in Massachusetts struck DOMA down on the ground of, is it a legitimate objective of the federal government to define what marriage is? And the principal part of the holding in the Massachusetts case is it's not really a legitimate objective because the federal government has never defined what marriage is. I mean, if there was a federal domestic relations law and a long history of the federal government dealing with definitions of marriage, that would be one thing. But the federal practice has always been marriage is how states define it. And so for that fairly narrow reason, is a legitimate objective, the district judge said, you know, it might be a legitimate objective of the states. That might be one thing, and I'm not ruling on that. But it's hardly a legitimate objective of the federal government to define marriage when for 200 plus years they've never had a definition other than what the states do is what marriage is. And so that's the posture right now of the Massachusetts cases. It's going up to appeal in the First Circuit. The second case is the Perry versus Schwarzenegger case, which deals not with the federal law, deals with the state constitutional provision. California back and forth over civil unions, domestic partnerships, gay marriage, statutes, reverses of statutes, and eventually a constitutional provision that's very simple, one sentence. In California, marriage is between a man and a woman, period. I paraphrase, but not by much. That's pretty much what it is. One sentence, very short. Constitutional provision, Proposition 8 put up. The public, public supported. I can't really remember what the margin is, but this is a case that was decided in early August. Again, the district court judge wrestles with rational basis. He kind of says it should be a strict scrutiny because gays and lesbians have been discriminated against. They are a discrete and insular minority under the Caroline Products test. Might be strict scrutiny, but I'm going to use the rational basis test, and I don't believe there's any rational basis to limit marriage just to opposite-sex couples. And it's a very lengthy opinion, but both of these are going to come up, and you're going to see Supreme Court or Circuit Court opinions dealing with DOMA. You're going to see Supreme Court or Circuit Court opinions dealing with the constitutional provision. And I think there may be a third kind of case in this area that would come up that I think is probably a kind of case you'll see come out of a place like Virginia. Virginia has a marriage amendment in the Constitution that was passed in 2006. And the marriage amendment is a little bit different than the California one. It says, and I will paraphrase, but that none of the benefits, responsibilities, obligations of marriage can be extended to anyone other than an opposite-sex couple. You can't extend it to a same-sex couple. And it's fairly definitive in terms of none of the obligations, benefits, et cetera, of marriage can be extended to a same-sex couple. The Virginia case, statute and others that are worded the same way could be susceptible to this kind of a challenge. Not a challenge hey, Virginia General Assembly, you must grant rights to same-sex couples. But there might be a constitutional challenge of, hey, if married couples can approach the legislature without a constitutional prohibition in their way to petition the legislature for laws, is it constitutional to block same-sex individuals from approaching the legislature to make their case? The fact of the constitutional prohibition means that there is one category of people that can't go to the legislature and say, hey, here's a bill we'd like you to vote on. Now, you might vote no on it, but at least we can come to you and ask you to vote on it. But once the constitutional prohibition is in place, Some people can petition the government, and some people can't petition the government. There's a Supreme Court case called Romer versus Evans that deals with a constitutional initiative in Colorado that basically said, homosexuals are not allowed to go to either local boards or the legislature and ask for rights specifically for them. And that was an initiative that passed, and it got in the Colorado Constitution. And in Romer versus Evans, the Supreme Court said, well, look, we're not saying that whatever anybody asks the legislature they're entitled to. But to say one group of people can't approach the legislature and ask for something, and other people can, there's not a rational basis that says that would uphold, no, one group of people can't go to the legislature. So there is a third potential kind of case that doesn't really deal with adjudicating marriage rights, but I think it deals with, are you blocking off some individuals' ability to petition the government when others have the ability to do it? These are very, very complex issues, and I think you're going to see this one go out over the course of the next decade or more. Finally, in the area of immigration, we started a couple minutes late, so I'm a couple minutes late, but I'll finish pretty quick. Two things have happened. Two things are happening right now in immigration that tie right back to this language where citizens get protection of their privileges and immunities, but persons get protections of due process, life, liberty, property, and equal protection of the law. The first is there has been a very significant amount of controversy recently about the number of Latinos, primarily, moving from Mexico to the United States who have children in the United States. And was it within the contemplation of the framers of the 14th Amendment? Should those children be U.S. citizens? Now, the language of the 14th Amendment that we were looking at is clear with a caveat. I'll talk about the caveat in a second. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the states wherein they reside. So parents come over from Mexico without documents, illegal immigrants. They have a child born in the United States. That child is a U.S. citizen. Some would argue that that child, having come with parents who are not here lawfully, are not subject to their jurisdiction thereof, within the meaning of the 14th Amendment. But there was a Supreme Court case on this in the 1880s called U.S. versus Wong Kim Ark that dealt with a Chinese immigrants who were not citizens in the United States, and they were here, and they had a child, and the child claimed U.S. citizenship, and went up to the Supreme Court. And the argument in the Supreme Court was, well, this child, Wong Kim Ark, may have been born in the United States, but he's not subject to the jurisdiction thereof because his parents were not U.S. citizens and not lawfully here. And what the U.S. Supreme Court said in the 1880s on that was, not subject to the jurisdiction thereof is a really narrow phrase, and it means, are you the child of a diplomat? So if you're a Chinese diplomat in the United States, you and your children are not subject to American law. You're subject to the law of China. But if you're not in a diplomatic family, if you're in the United States, you're subject to the jurisdiction of the United States. So this issue of, should these kids who were born here to illegal parents, the kind of pejorative phrase that some use to describe them as anchor babies, should these kids be U.S. citizens or not? It is rock solid clear in the Constitution that they are U.S. citizens. But there has been suggestion that some would want to have hearings and think about, should we redraft the definition of citizenship in the 14th Amendment? The second issue that's kicking around on the immigration side is this issue that was decided in the Plyler versus Doe case, which is not about citizens, but about persons. So persons are entitled to equal protection of the laws. And so in Plyler versus Doe, which was a case from Texas, Texas had said, you know what? Our schools, compulsory education, going to educate everybody. We're not going to educate kids who are not lawful immigrants in the United States. And the Supreme Court in 1982 said, no, these kids are entitled to equal protection because they're persons. They may not be citizens, but they are persons, and they're entitled to equal protection, so they get to go to school. But it was a 5-4 decision. It was a very narrow decision in 1982. It hasn't really been revisited by the Supreme Court since then, but the court has changed a lot in its composition. That was an opinion that was written by Justice Brennan. It's changed a lot. So I'm not aware of cases that are percolating up dealing with this issue of equal protection for persons. Okay, I mean, does that mean 100%? I mean, or is it in everything that we do? Something like education. There's not a right to education in the Constitution. Education is a discretionary service at least under the federal Constitution. There is a right in state constitutions, Virginia and probably Texas too. But I think this issue of how broad the Equal Protection Clause protects non-U.S. citizens is one that's going to be a pretty hot area going forward. All right, well, I've just rattled on for, an hour and 5 minutes, but let me just open it up and see, and I'll stay and visit if folks want to. Just a word of conclusion, then I'll open it up. In my view, the non-constitutional scholar and non-historian's view, the First and 14th Amendments are the heart of our Constitution, and really the heart of our system of government, and not to demean the importance of any other amendments, but I gave a talk recently that some of you were at an ethics seminar here about the First Amendment, which is a very complex amendment because it protects beliefs, it protects expression, it protects association, and it protects advocacy. And my argument about that amendment is it was first for a reason, and the protection of religion was first in the First Amendment for a reason. And the First Amendment is more than just a protection of individual rights and more than a check against governmental power. It's also a theory of knowledge, how knowledge develops. We have beliefs, and then we're free to express, and we're free to associate, and we're free to advocate. And in that combination of belief and expression and advocacy and association, we test ideas against one another, and we learn, and we get more perfect because we learn more things. And there's a lot of textual evidence that that's exactly what folks thought who were drafters of key parts of the First Amendment, that it was less about individuals and it was more about we need to have an open mechanism for discussion and robust dialogue, because that's the way you find, in Jefferson's words, that's how you find truth and that's how you eliminate error. So it's more than individual protection. It's about finding truth and eliminating error. That would be the First Amendment. The 14th Amendment, all of these phrases, all equality, due process, the definition of citizenship, privileges and immunities, the incorporation of the Bill of Rights into protection against states. The 14th Amendment really was in many ways almost a redraft of the Constitution. It was so vast in what it did. They are also two of the amendments that are probably, because of their core to who we are as a country, are the most fertile in terms of controversies and debates. If we'd been on the First Amendment, we would have talked about, the construction of mosques as opposed to churches and synagogues in Lower Manhattan. There's always, and there's a fascinating First Amendment case that's going to be argued at the Supreme Court in the next couple of days. I think University of Richmond students participated in this moot court. Am I right, Dean Douglas, about the hate speech case that's going to be argued? Hate speech, can we push away hate speech that's dramatically uncomfortable at military funerals? Or does Congress shall make no law mean Congress shall make no law even with respect to, some of the speech that we would find the most offensive in the most offensive circumstance? So the First and 14th are really kind of where the action is, where they're going to be. And these three areas are, definitely kind of proof of the proposition that there's a lot of questions that we still have to solve, and there's going to be a lot of interesting debate about them on the way down the road. I will stop now, and I'll open it up and take a question or two, but then I'll stand around and visit as well, because some of you may have other things that you need to do. So I'll open it up and see if there's a question or two. All right, well, I'm going to stand around and visit. Thank you all for coming. It's great to have you here.